We are set today for final trial in this case, and the court will recognize that the department is present this afternoon, represented by Ms. Marilyn Bradley and joined by Mr. Ramon Aranda with Belong, as well as Christy Knopp with Belong. In addition, we have Ms. Elizabeth Fisher here. Ms. Fisher is the attorney for the respondent mother, Ms. Priscilla Benton. I don't believe I see her present as of yet. Mr. Richard Saldivar is here. He is the attorney for the respondent father, Rodney Arias, and the unknown father. I don't believe either are present. Ms. Anna Swallow is here. She is the attorney for the respondent father, David Arias. He is not present, but we do have Ms. Alana Pearsall here on behalf of the respondent father, Oscar Trevino. I don't believe he is present, but he has, I believe, executed a relinquishment. I will also take it back. I do see Ms. Benton present, so I'll have the record reflect that Ms. Priscilla Benton is here. And we additionally have Ms. Kathleen Savage present. Ms. Savage is the attorney and guardian ad litem for the children, and Ms. Connie Lopez is here with CASA of South Texas. And I believe I see Ms. Elizabeth Hansen here as well, with Belong, I believe, as well. So it is nice to see you. All right, well, let me ask Ms. Bradley first for announcements. I'll ask for everyone how you wish to proceed with trial this afternoon. What is the department's position, Ms. Bradley?
Your Honor, the court ordered mediation and we were able to reach a Rule 11 agreement, which has been filed as an exhibit. Mr. David Arias was not present, so it is my recollection that everyone else was in agreement that we start the trial today by accepting the affidavit of relinquishment tendered through Mr. Oscar Trevino's attorney, in which he relinquishes his parental rights to Selena. Prior to that, I think we may want to address the pending motion to transfer and consolidate, which involves the child support order for Selena that was issued requiring Mr. Trevino to support this child. I did provide an order to everyone, and I believe the court has it as well. So we would then like the court, after receiving that evidence and of course best interest evidence, to reset the case, to give us time for Mr. David Arias to get the DNA test results back. He did travel yesterday with Mr. Aranda to be tested, and he did submit a DNA sample, but I think the AG has been a little bit behind. It was very difficult to get this scheduled. So we would probably, I think we all agreed that sometime in early May would be probably the most, would be the best time to reset.
All right. Thank you for that summary, Ms. Bradley. And I'm looking at the motion to transfer and consolidate that you referenced. And that was a case from LaSalle County, correct?
Yes.
All right. And okay. Let me then ask the remaining parties your announcements. Ms. Fisher, what is your announcement? Are you in agreement with the plan that Ms. Bradley has proposed today?
Yes, we are.
Okay. And same question to you, Mr. Saldivar. Do you have any objections to proceeding, addressing Ms. Pearsall's client, and then resetting the remaining matters for trial at a later date?
No objection, Your Honor.
All right. Ms. Pearsall, are you ready to move forward as far as your client is concerned?
I am, Your Honor.
Okay. And Ms. Swallow, does this plan adequately address, in and I see Mr. Arias is joining us now. Your client is joining us. Are you in agreement with the plan proposed by Ms. Bradley?
Yes, Judge, I'm in agreement, but I will have to announce not ready for today.
All right. All right. Let me also ask Ms. Savage, on behalf of the children, is this a plan that you support as well?
Yes, Your Honor, it is.
All right. Well, let me then, if that is the case, allow you, Ms. Bradley, to start. We'll commence the trial, get testimony started, and we'll focus our testimony today on the father, Mr. Oscar Trevino, and try to address him completely. If we're able to resolve testimony regarding him, that would be good. So let me let you call your first witness. Who will that be?
I believe that would be Ramon Aranda. And Mr. Aranda, how long have you been on the case?
I've been on this case since the start of the case.
Have you ever been able to meet with Mr. Oscar Trevino?
I have not. I've attempted every month to make contact with Mr. Trevino, and I have been unsuccessful each month.
How did you attempt to contact Mr. Trevino?
I've gone to his house every month, at least twice a month. I actually know Mr. Trevino personally. We live in the same town. I've left my contact information. I've left him letters. I've left him information regarding court. I've left him information regarding contact to his attorney. He has never made any efforts to contact me.
All right. In your case file, do you have a copy of his waiver of service?
The relinquishment, is that what you're asking?
No, sorry, where he waived service, where he was provided with all the documents when this case began and he waived service. Is it in the case file?
I don't know if that's in the case file.
Was it e-filed with the court, to your knowledge? I sent you that document, Petitioner's Exhibit number 3.
Your Honor, no objections.
No objection.
Are you offering petitioners 3, Ms. Bradley?
Yes, I will offer 3, Your Honor, as well as 4, 5, 6, and 6.
All
No
right.
objection.
No objection.
Okay, I don't hear objections from any party. So petitioners exhibits 3, 4, 5, and 6 are admitted.
Thank you. So, Mr. Aranda, since Mr. Oscar Trevino, according to the exhibit number 3 that has been admitted, he signed the waiver of relinquishment. To your knowledge, would that indicate he's aware that there is a removal action and has been aware since the date on the face of the document?
He is aware. He's always been aware of the case.
Okay. And are you aware that he has executed an affidavit of relinquishment of his parental rights for Selena?
Yes, ma'am.
Okay. And are you aware that there is a pending case out of LaSalle County for child support, ordering Mr. Oscar Trevino to pay support for Selena, that the department has filed a motion to transfer and consolidate with this case?
Yes, ma'am.
All right. Your Honor, at this time, we would ask that the court orders the case to be transferred and consolidated.
All right, is there any objection from any party for the court doing so at this time?
No objection.
No objection.
No objection.
No objection, Your Honor.
All right, then the motion to transfer and consolidate is granted.
Have you seen the child, Selena?
Yes, I see her every month.
Okay. And do you actually go like in person and talk to her?
I have every month I visit with her. If not at home, I visit with her at school.
Okay. Have you asked her about Mr. Trevino, if she sees him frequently, or do you know if there's contact?
We talk about her dad. She really, as much as she would want him in her life, she knows that he doesn't want to be a part of her life. She reports she has the siblings. He has other children, her age and younger. She has them on her social media, and she reports to me that she has them because she wants to know what they do, what places they go. She wants to keep up with her dad through social media, but she knows that her dad doesn't want to be a part of her life because he doesn't make that effort.
And did you indicate, I'm sorry, I wasn't clear, if you're suggesting or indicating that that is harmful or emotionally detrimental to her?
I'm sure it is, but I don't see that from her. She expresses that she hasn't seen her dad in the last 2 years. He hasn't been around. She knows he doesn't provide any type of support to her mother. So I'm sure it hurts her, but she really doesn't. She's used to that life. I mean, she knows that he's not going to be a part of her life. She accepts that.
All right. Where is the child at this time, Selena?
Selena lives with her aunt in Cotulla.
Okay. And have you been to the home?
Yes, about 3 weeks ago was the last time I visited in the home.
Is it a safe, stable, and appropriate placement for her?
It is. It's a very safe place. It's a LaSalle County Housing Authority. It's an apartment under housing.
Can you tell if Selena has any relationship, good or bad, with Miss Munoz?
Selena has a very good relationship with her aunt. Prior to the case, Selena was already living with her aunt. Prior to living with her aunt, Selena used to live with her grandmother in Cotulla. Her grandmother passed away, and she moved from grandmother to aunt, and she's been there since. I believe she's been with her aunt about 2 years now. She's very happy with her aunt. She's very vocal about wanting to stay with her aunt.
All right. Do you believe that that would be in the best interest of Selena to stay there in this placement?
It is.
Okay. And what kind of care is Ms. Munoz able to provide for Selena?
Well, she's able to provide for her physical, for emotional, for her medical needs. Selena's very happy with her aunt. Her aunt is, she wants to keep the kids. She wants to provide for them because she knows that they need her, and she's able to provide what her sister is not able to provide for those kids.
And the younger brother, Aaron, is there in the home as well, is he not?
Yes, ma'am.
All right, so she's with her half sibling, correct?
Correct.
All right, so given the fact that Mr. Trevino has not had contact with Selena in the last 2 years, and that everyone else, I'm sorry, not everyone else, Ms. Munoz is providing the care and all the necessities that Selena requires, do you believe that it would be in the best interest of Selena for the department to accept the affidavit of relinquishment signed by Mr. Trevino?
Yes, ma'am.
All right, and that document, have you seen it?
Yes, ma'am, I have.
And it's properly notarized, correct?
Correct.
It is not signed by you, however, as agent for the department to accept the relinquishment. Would you be willing to add your signature to that document, or in the alternative to inform the court that you do accept the relinquishment on behalf of the department?
I would.
All right. And is the department proceeding only on the K ground of voluntary relinquishment in its petition to terminate Mr. Trevino's parental rights for Selena?
Yes, ma'am.
All right. And that was pursuant to the Rule 11 agreement. That is petitioner's exhibit number 4, correct?
Correct.
Thank you. Pass the witness.
All right. Ms. Pearsall, do you have any questions for Mr. Aranda?
The department has agreed to waive any and all child support that could be owing to the department by Mr. Trevino. Is that correct?
Yes.
Now the questions.
Thank you, Your
All
Honor.
right.
Mr. Aranda, if Mrs. Vitten's parental rights are not terminated to Selena, does the department still want to terminate the father's rights regardless?
Yes.
Now you realize that if Mrs. Vinton's rights aren't terminated, that you're asking the judge to cut off her right to get child support going forward.
I'm not sure I understand that.
You testified that the department's willing to waive any child support that's owed to the department, correct?
Yes,
So that would be child support that has been paid during the pendency, since the department has been the temporary managing conservator, correct?
yes, ma'am.
So, and if there's child support from before, then you're not waiving that, obviously. You can't waive that, correct?
Correct.
Now, if Miss Vinton, if her rights are not terminated and Selena goes home to her, if the father's rights are terminated, she will not be able to get child support from him in the future. Do you realize that?
That is correct.
And you're comfortable waiving that for her, basically?
Yes,
Think you have the authority to waive her ability to collect child support from the father in the future?
he hasn't paid regardless.
Objection, non-responsive.
Sustained. Listen to the question, Mr. Aranda. Want to ask it again?
Sure. Okay. Mr. Aranda, you realize that if his rights are terminated and Miss Vinton's rights are not terminated,
Mhm.
that she will not be able to collect child support from him in the future.
Your Honor, I'm going to object to this
Right.
line of questioning. There is a Rule 11 on file by all parties, including Ms. Fisher and her client, agreeing to accept Mr. Trevino's relinquishment.
I didn't agree to accept it. I just agreed that that's what they were going to do. It has no, I mean, and I certainly didn't agree for my client to have any of her rights waived through this. For them to present it, that's not an issue, but I think it's a very invalid question, given that we're not proceeding on my client today, and they're just assuming her rights will be terminated.
All right, I'm going to overrule that objection.
Mr. Aranda, do you understand that you're taking away her ability to collect child support in the future?
I understand that. I'm just answering based on the agreement we had prior to this.
Objection, non-responsive after I understand. Do you think that that would be in Selena's best interest, that Ms. Vinton not be able to collect child support in the future?
Probably not.
Thank you. I'll pass the witness.
I have a question, Your Honor.
Oh, I'll get back to you for redirect. Let me just ask if Ms. Savage has any questions.
No questions, Your Honor.
All right, Ms. Bradley, do you have any?
Yes, Your Honor. Mr. Aranda, you testified earlier that Selena had been in the care of her grandmother and then the aunt. Do you know if Selena was in the care of her grandmother for a significantly long time?
She hasn't been with mom. At the last 2 years, she has not been with mom.
Okay, but
Even
that's not what
prior
I,
to that,
go ahead. Go ahead.
even prior to the removal, she was already living with grandma at least a year prior to removal.
Okay, so basically, other people have been caring for Selena, not Miss Vinton, correct?
Correct.
And so Miss Vinton technically did not provide care and support for Selena for at least, according to what you're saying, for the past 3 years.
Probably so.
And how old is Selena now?
Selena is 12 years old.
Okay. If the court chooses not to rule on the termination of Mr. Trevino's rights at this time, is the department prepared to re-urge that motion when the court reconvenes?
Yes, ma'am.
Thank you, Mr. Aranda. Pass the witness.
All right. Anyone else have questions for Mr. Aranda?
Yes,
Yes,
Your
Your
Honor, I have one.
All right, Ms. Savage.
Ms. Aranda, Ms. Vinton has expressed to you a desire to relinquish us to Selena. Is that correct?
It depends. It depends on when I go. There's months that she's in agreement. What's March? When I met with her this month, she gave me a different story. Last month, she was in agreement with her sister keeping her, adopting her daughter, Selena. This month, when I met with her, she says, no, I don't want her to get adopted. I don't mind her staying and continue to live with my sister. I just don't want my rights terminated. I want for her to decide when she turns 18.
Okay, but
She referred to it as graduation. She meant 18. Yes.
essentially she expressed desire to not have Selena back in her home, correct?
Well, and it comes down to that she knows where Selena stands regarding coming back to mom. Mom understands that Selena does not want to reside with her. She wants to stay with her sister.
Okay, I'll pass the witness.
All right, and was it you, Ms. Pearsall, that indicated you had another question? You may urge that question.
Thank you, Honor. Mr. Aranda, you understand that we're starting trial today, correct?
Yes, ma'am.
Okay. And is it the department's intention to seek termination of all parental rights through this trial?
Yes.
No other questions?
All right,
I have one more question, Your Honor.
yes, Ms. Fisher.
Okay, Mr. Aranda, isn't it true that Ms. Vinton would like both children back with her, but she may realize Selena doesn't want to be there?
True.
But she's never said she didn't want Selena back, has she?
She's never said she does not want either. She wants both kids back
Okay.
with her.
Okay, thank you. Thank you.
All right, any other questions for Mr. Aranda as they relate to Mr. Trevino?
I have one, Your Honor. I'm sorry.
right. That's-
Mr. Aranda, have you not reported in the past that Selena did not wish to go home to her mother?
Selena has always been vocal on that. She's always stated she's very happy where she is. She does not want to go back with mom
And
from the beginning of the case.
And has Miss Vinton has she expressed to you that this is what she wants, for Selena not to come home to her?
Your Honor, Judge asked and answered. She's trying to revamp his testimony. He already testified.
I'm just trying to understand, Your Honor.
Ms. Vinton,
I'm just gonna overrule and you can answer this question, Mr. Aranda.
Ms. Vinton has never told me she doesn't want the kids. Ms. Vinton has always been vocal about wanting the kids. She's doing services. She's always been, very punctual about doing all her services because she wants her kids back. But the problem is she just doesn't want, or she just doesn't leave the source of the problem, which is Mr. Cantu. Other than that, Ms. Vinton has done everything that we've asked of her because she wants to get her kids back.
Okay, thank you for clearing that up. I appreciate it, Mr. Aranda. Thank you. Pass the witness.
All right, let me ask then if there are any other witnesses you wish to call, Ms. Bradley.
No, Your Honor, I do not.
All right, and Ms. Pearsall, do you have any witnesses you wish to call?
No, Your Honor.
Okay. Just so that I understand everyone's expectations and what we discussed when we started, does everyone feel that this is a good stopping point for purposes of commencing the trial and addressing the matters you wish to for today?
Yes, Judge.
Yes.
Yes, Your Honor.
I have to say that I am inclined to reserve judgment regarding Mr. Trevino. I do think that in this situation, if there's a contested termination as to Miss Vinton and Selena, that the issue of whether or not to accept the relinquishment of Mr. Trevino is something that needs to be considered in regard to the rest of the testimony this court may hear. So I'm not prepared to render judgment today as to Mr. Trevino, but I think we're at a good stopping point to recess the proceedings and then reconvene them within the 90 days. And I believe you mentioned you were looking at early May as the best option for coming back. Was that your request, Ms. Bradley?
Your Honor, I believe that is in the Rule 11. I think that was what we said. I'm just
I was
double
trying to read
checking.
that too. I just, I can set it on May the 5th at 10, or I can set it on May the 19th.
That works.
Um, We could do 11 o'clock on June the 2nd.
Works.
I'm available, Your Honor.
All right. So we can set it on June the 2nd at 11. And then to make it clear, you all referenced the in-person proceeding on another matter, but what is the preferred format for this proceeding? Does everyone wish to maintain this as a Zoom trial?
Yes,
Yes,
Judge.
please.
Yes,
Yes,
Your
Your
Honor.
Honor.
All right, then so it will be. We will proceed and continue the trial on June the 2nd at 11 via Zoom, and we'll pick up from where we left off today. Is there anything else, other matters that we need to address while we're here?
I just would like to ask, how long do we anticipate needing on June 2nd?
If it's contested, I would say at least 2 or 3 hours to prove up mom's termination.
Will we stop for lunch?
I mean, I think everybody will probably need to eat a little bit, so including the court. Because I have a morning docket, so it's not like I'm going to have court prior to that.
And I don't know what my client, if he's not the father, then it's, that's going to be a different scenario than if he is the father.
So that's why I brought it up. Could we maybe have the rest of the afternoon, just in case we need it?
Yeah, we'll mark that as well. Should we just set it for 1? Is that easier for everyone? Do you think an afternoon would be better? And then that way, if we have another case we need to add to that docket, it's blocked for that morning. So if one works better, we can do it then.
Yes, Your Honor.
That's fine.
Yes, Your Honor.
It doesn't.
Okay. Then let's go ahead and set it then for 1 p.m. on the 2nd. Ms.
Thank you.
Knopf?
I did want to let you know that Ms. Hanson is taking over the unit that Ray is in. And so she will shortly be taking over, and I will not be supervising that unit. I did want to let you know why she was here, Your Honor.
Well, that's very good news. So great to have you on board, and it's great to see you in my
Likewise.
court.
Thank you.
Look forward to working with you. So let's thank you for that, Ms. Knopf. I appreciate that update, and I will see you all on June 2nd at 11 hearing regarding the department's petition for temporary managing conservatorship of the child, and the court will recognize that the department is present this afternoon, represented by Ms. Marilyn Bradley, and joined by Miss Veronica Orozco and Miss Joanne Goodwin. We also have Miss Catherine Shove here with Belong. In addition, we have Miss Kathleen Savage present. Miss Savage is the attorney that's been appointed to represent the respondent mother, Jennifer Torres. Ms. Torres is present as well. We also have Mr. Marco Cabrera here. Mr. Cabrera is the attorney and guardian ad litem for the child. We are missing Miss Irene Acosta. Miss Acosta was appointed to represent the respondent father, David Lewis, who is also not here. And we have representatives from CASA of South Texas also present, but not yet on the case, right? I don't think we've made the appointment yet. So, but let me ask, did you already send a reminder link? Okay. Ms. Acosta is joining now. And once she's on board here, I think we can go ahead and get started. Ms. Bradley, can I get announcements from the parties regarding how you wish to proceed this afternoon, and if you're ready to proceed, and I'll let you start.
Yes, Your Honor. It is my understanding that Mr. Lewis, David Lewis, was served back on the 16th, but we don't have those documents showing service. Ms. Torres is here, of course. We are prepared to go forward today. It is our understanding that this is not a contested adversary, that neither parent is able at this time to provide a safe, stable, or appropriate home due to various factors. I believe Ms. Torres has other children in the home, and right now the child is in an RTC. So that is my understanding of the case.
All right. Can you just share what led you to believe, or your understanding, that Mr. Lewis was served on the 16th of March, even if you don't have the actual physical return of service back in the file?
Yes, Your Honor, in conferring with Ms. Veronica Orozco, who is the investigator on this case and is present today, she did some checking because Mr. Lewis lives in Houston and there had to be a courtesy worker there that was utilized. And in fact, there's a courtesy worker in San Antonio, but I believe she has not located Ms. Torres is here, but that is how I was able to make that determination through the investigating efforts of Ms. Orozco.
All right, so she would be able to provide testimony regarding how she has learned about him being served.
Yeah.
Okay.
Yes.
All right. Well, let me ask then, Ms. Savage, can you provide your announcement on behalf of Ms. Torres this afternoon?
Yes, Ms. Torres was in agreement to TMC to the department. Obviously, no agreement of any admission of abuse or neglect. We did not have any agreement as to services. So I think the agreement was to discuss those at a family group conference at a later date.
All right. And was there any discussion about visitation or communication or access?
No.
Okay. All right. Ms. Acosta, have you had any communication or contact with Mr. Lewis?
No, Your Honor, I have not.
Okay.
I would announce not ready.
Okay. And then, Mr. Cabrera, what is your position this afternoon?
Your Honor, I'm in agreement with TMC.
All right. Well, I think under the circumstances, if there is evidence that can be presented to this court, including testimonial evidence regarding service of Mr. Lewis, then we can go forward and the court can hear that. And so I will allow you to address that along with the need for temporary managing conservatorship. Ms. Bradley, I'll recognize and record for the record that I understand, and I hope everyone has heard Ms. Savage's announcement on behalf of Ms. Torres that she is in agreement regarding the department's appointment as temporary managing conservator. So we would need evidence that would justify and address Mr. Lewis's position and why he may not be potentially available or an option for placement. So I understand you're not a ready announcement, Ms. Acosta, but we're going to hear testimony. This court has been informed that there is evidence, not a return of service in the file, but evidence that can be shared through testimony regarding your clients having been served with citation on March 16th. So I want to have that introduced into the record. And we're going to go forward to hear that. And I'd like to start with that and then move into other testimony.
I'd like to call Veronica Orozco.
You may proceed.
Thank you, Your Honor. You are Veronica Orozco, is that correct?
Yes, ma'am, I am.
And are you the investigator with the Department of Family and Protective Services who has been assigned to investigate?
Yes, ma'am, I am.
And Ms. Orozco, how old is Jordan?
Jordan is 9 years old.
And where is he now?
He is currently in placement, and he is actually going to be moved to an RTC tomorrow. Do you need the name of the RTC?
Yes.
Okay, the judge is
I'd
nodding
like to
yes.
know.
Okay. All right, so Ms. Orozco, how did you happen to become involved in this investigation?
So initially, this case came in as an alternate response case. I'm the alternative response caseworker. So as soon as I was calling my collaterals, reading the information I got, I felt that I needed to change it into an investigation because grandmother was the one that had this child. She had him for about 2.5 weeks, and grandmother basically told me that she was not able to care for the child, that parents needed to take care of the child because she was not willing to take care of the child.
Your Honor, I'm gonna object. It was my understanding that we were going to verify whether or not.
Yeah, we need to
Mr.
start with the service
Okay.
issue. That
I'm sorry. I was just trying to lay a little groundwork, but I will revert back to the original plan, which was addressing service. Ms. Orozco, so you have indicated the child is in Houston.
Correct.
And did you determine where the father and mother of the child live as well?
Yes, father lives in Houston. Father is custodial parent to Jordan, and mother lives in San Antonio, and child was in Pearsall when the removal happened.
All right. And did you have any assistance from another employee of the department or a subcontractor? Did you get any assistance in making contact with Mr. Lewis?
Yes, ma'am, I did.
And can you explain to us what that was?
So since Mr. Lewis does not live in Region 8, I do have to get a courtesy worker to go out there to talk to parent. So I had sent out a courtesy, and in my documentation, Miss Dana Spencer was a courtesy worker that works in the Houston area for Child Protective Services in the investigation department, and she made contact with Mr. Lewis on March 16th.
All right. And did you verify with Miss Spencer that Mr. David Lewis had been notified of the proceedings and or served with paperwork regarding the hearing today?
In her documentation, she did put that she did give him the paperwork, and I did verify that about 5-10 minutes prior to the court. I wasn't able to call her, but I did verify through documentation purposes that she documented.
I'm sorry, I'm gonna interject. So she's provided, did you see an execution of a waiver of service?
No, I didn't see her upload that. She just, let me upload. She put here that she had given Mr. Lewis the documentation, and she advised him that she went over paperwork, who his attorney would be, and court date information.
Okay, Your Honor, at this point, I'm going to object to moving forward with the hearing because that's not personal service of my client.
That's why I was asking for clarification as well. That's not service as far as I can hear either. And so, and especially if he's the listed custodial parent, I think we have to have the service before we can proceed. I think we need to extend the emergency orders in this case and recess and reconvene to allow you to get him served. I mean, have you, Ms. Bradley, can you verify that the necessary request for a citation has been made and is in the Houston area for execution and delivery, or that efforts are being made to have him enter a waiver of service?
Your Honor, I had inquired about whether or not a waiver was obtained, and Ms. Orozco was indicating to me that the paperwork had not been uploaded. So I don't know if I don't know if it was simply an oversight in uploading or whether he was not provided with that document.
All right. Well, I think that those questions would need to be answered before we proceed, and we need to ensure service. So let me look at what our options are here as far as Assessing and reconvening. Will the court will extend the emergency orders that are in place, and we will be back on the 29th of March at 2 p.m., correct? Yeah, at 2 p.m. To reconvene.
Thank you, Your Honor.
Thank
All
you.
right.
Your Honor, thank you.
Thank you. And Ms. Orozco and Ms. Acosta, I'm asking you to touch base with each other regarding Mr. Lewis's contact information so that Ms. Acosta can reach out and make contact with him as well and try to ensure his participation in the hearing on that
Ms.
date.
Acosta, do you have my telephone number?
All right, thank you.
Thank you.
Thank you so much.
Thank you.
Thank
Have a
you.
good day.
You as